Equality, liberty, and the right to intoxication, the right to relaxation and well-being, and the usefulness of education to deal with the limited dangers of cannabis were all proudly proclaimed as arguments in favor of the re-legalization of personal amounts of cannabis in the Lubeck case. 2 years later, the higher courts shifted the focus of the trial from abuse reduction to demand reduction, and then dismissed the effectiveness of education on use rates. In the Lubeck decision, it was written that the laws against cannabis possession were a contravention of the principle of equality before the law, on the grounds that alcohol and nicotine are not included in the schedule. The court clearly considers that it has been established that alcohol and nicotine are clearly more dangerous, that cannabis products, they're more dangerous than cannabis products. Although smoking cannabis can lead to lung damage, this is insignificant when compared to the damage caused by smoking tobacco products. In R versus M, bracket C, a case involving consensual anal sex between young people, the Ontario Court of Appeal struck down the offence as contrary to the Charter. While it is true that both cannabis use and anal sex may be moderately risky, they are both acceptably risky, and if done properly, harmless. The connection between both groups of harmless hedonistic deviants is made clear when the ruling is read aloud. It could very well be about young people using cannabis. It strikes me as decidedly inappropriate to deal with health risks at any age by using the punitive force of the criminal code, but especially so for young people. Health risks ought to be dealt with by the health care system. It is not enough for a government to assert an objective for limiting guaranteed rights under Section 1. There must, in my view, also be an underlying evidentiary basis to support the assertion. That goes back to burden of proof there. Justice Iacobucci and Justice Corey in Vrend, and again with Justice McLaughlin and Justice Iacobucci in Corbière, outlined the standard for inclusion in Section 15 protection. Apparently, the test is that one must be in possession of a, quote, historical, social, political, and economic disadvantage suffered because one is in possession of a deeply personal characteristic that is either unchangeable or changeable only at unacceptable personal cost. There are two responses to this. One, the intelligent preference of cannabis over other drugs is changeable only at unacceptable personal costs. And two, it is unacceptable to submit to any dictates from above regarding harmless activities or characteristics, no matter how trivial or marginal or changeable they may be. If we take the first approach, we might point to the fact that in 1991, THC receptors were located in the brain. This might lead us to believe that THC control is a form of self-control, and that what is seen as inherently pathological addiction is in fact attraction to using our own minds and bodies more effectively. Prohibiting us from using our own THC receptors is an unacceptable personal cost. But in my submission, the second approach is more in accord with natural justice. Instead of wasting time trying to explain how intelligent health choice preferences are as unchangeable as sexual tastes or religious choices, I would rather argue that the court has set the standard for Section 15 inclusion too high. It matters not if the next war is on those who eat fatty foods, or those who like spanking with their sex, or those who like to skydive, or some other non-monumental, easily changeable choice that a person makes. If it's a harmless choice, it doesn't matter how changeable it is. If it needs changing, the person can change it themselves. They don't need the government breathing down their necks telling them how to live their lives. A line has to be drawn somewhere, and in my submission it's better to protect all harmless personal characteristics rather than just the unchangeable ones. One of the reasons given for declining to protect the sexual orientation of Rend was the assertion that sexual orientation was a marginal ground. Now, how is this any different from saying that cannabis orientation or preference is a changeable ground? In both cases, the authorities are arguing that the targeted characteristic of the scapegoat is too unimportant to protect. The Crown has written that extending equality rights to the users, growers, and distributors of cannabis would also apply to all drug crimes, resulting in total drug re-legalization, and would also apply to incest, resulting in incest legalization. If the Crown is arguing that ending the war on pot might end the war on drugs, let's all hope this is so. Black market harms are limitless, whereas the drug abuse harms are mitigatable. If the Crown is arguing that re-legalizing pot will legalize incest, I can't see that happening. Violating the sacred trust of Platonic family roles does cause a form of harm, even when consent is present. The harm is that the child is denied the right to develop in a safety zone where love is unconditional and the many perils of sexuality are not present. Everyone knows this. That's why nobody is calling for the legalization of incest. All of the Crown's many arguments fall into one of two main categories. They are either attempts to associate black market harms as inherent harms, or attempts to rationalize criminalizing harmless behavior. The following is a list of the different unjustifiable arguments found in the Crown's factum, paraphrased for brevity. After each argument is the counter-argument, also paraphrased for brevity. All of the responses below can be backed up by expert testimony should it be required. Keeping in mind the burden of proof should first be on the Crown to back up their inherent harm claims. 1. Since this is the Crown's primary argument, a more in-depth exploration of this response is required. The Crown writes, to criminalize an activity, the Charter only demands a, quote, reasoned apprehension of harm that is not trivial. In my submission, it is not hard to see the next step of this slippery slope. Gay lifestyle as harmful as scientific, says Dr. Grant Hill, the Canadian Alliance leadership candidate. He said in a recent interview in the Globe and Mail. The obvious question is, would factors like AIDS and STDs allow a court to conclude a, quote, reasonable basis for concluding that harm will result from homosexuality to be sufficient for a return to the anti-sodomy laws? The answer has to be no, if we are to count our society as civil. If a distinction is not made between an inherent harm and a risk to self, and the reasoning of Parliament does not include this distinction, then it cannot be properly called a reasoned apprehension, for it is unreasonable to exclude this distinction. The pornographers found in Butler, the case Butler, the source of the reasonable apprehension of harm test, were those who created or distributed, quote, scenes involving violence or cruelty intermingled with sexual activity, or depicted lack of consent to sexual conduct, or otherwise could be said to dehumanize men or women in a sexual context. The criteria for inclusion in the objectionable material category was written broadly enough to apply to many sections of the Bible. Butler has done nothing to protect women from misogynist literature, but has been used to target lesbian and feminist pornography. The dehumanizing pornographer depicted in Butler is a tiny fraction of the population whose promotion of suffering, even if no children or actual rape is depicted, are bad advice type of harms that are better addressed by public condemnation, the promotion of more humane, inspirational, and educational sexual materials. If we are serious about the prevention of future cultural genocide, we must follow the criteria found in R versus M, the Umyet report, and Germany's Lübeck decision, not the narrow wording found in Butler. wording which excludes the possibility of harm reduction. 2. All non-medical necessity use is actually non-medical use, and therefore not legitimate use. In my submission, medicine isn't just about doctors and knives and needles and pills and safety and efficacy tests that kill 1 million rats. It's also about R&R and smoke turbal expectorants and of the prevention of stress and of performance enhancement and laughter. 3. The result would not have been different if the evidence Mr. Malmo-Levine attempted to admit had been admitted. In my submission, perhaps having an expert say the evidence would allow the courts to recall all the harm reduction evidence and address it. 4. Occasional recreational marijuana use is not of fundamental personal importance. It's trivial and not worthy of charter protection. In my submission, this is like saying that sexual orientation is too marginal a characteristic to protect. 5. The Crown's preferred argument is that the harm principle is not a principle of fundamental justice. It is a principle in the eye of the beholder only. The state doesn't need to empirically demonstrate to any court the harms they purport to be legislating against. Rather, the supervisory role of the courts is limited to ensuring that the sanction of incarceration is not utilized in an irrational or arbitrary manner. In my submission, if the state, with all its resources, cannot empirically demonstrate the inherent harms it purports to be legislating against, it has no business legislating in that direction. If the sanction of incarceration disregards Section 7 and 15 of the Constitution, if it disregards liberty, if it disregards autonomy and dignity and equality, if it disregards the harm principle, if it disregards other social or legal means of dealing with concerns over abuse, such as harm reduction, education, and regulation, if it disregards all that, it will indeed have acted in an irrational or arbitrary manner. In my submission, the harm principle is the negative corollary of the golden rule, in that the one thing you do not do unto others is harm. If the harmless are in any way harmed, there is no fundamental justice. The harm principle is the scientific version of the one ethical constant in every religion on the planet, the eye of almost every beholder. The harm principle is also found in Thomas Paine's Declaration of the Rights of Man and Citizen, right number 4 and 5, and in Mill's on Liberty. 6. If the test is that the harm has to be significant, this could lead to an unjustifiable intrusion into the lawmaking by the courts. In my submission, a line must be drawn somewhere, or all pleasurable risks face prohibition. There is no lawmaking by the Supreme Court in this case, as this argument only pertains to reading down or striking down of bad legislation, not the making of new legislation.